Good morning.
Morning, Your Honor.
Do I have everybody here? It looks like I do. So for the court reporter's benefit, I'm just going to formally call the case so she knows where to start. This is going to be a hearing on motions to dismiss in the matter of GAD or Gaddy, derivatively on behalf of Pratsana LLC versus Red Clay Development Group and Vilas Patel. The case number is 24CV014211. If I could get announcements for the court reporter and the court's benefit.
Good morning, Judge. My name is Aaron Kapler. I represent the plaintiff.
Okay. And who do I have here on behalf of the defendant?
Good morning, Your Honor. Jeff Zachman with Denton's on behalf of the defendant and counterclaim plaintiff. I have here with me my colleague Sarah Hannah Phillips and Mr. Patel, client representative.
Okay. As a brief aside, I noted a couple of things. One, you have a court reporter, so you have an official transcript. But just so you know, these are when they take place by Zoom, they're also live streamed. So there will be a clip of this on YouTube. And also, I did note somebody sent me a notice that there was someone, an AI generated meeting note taker. Those are all fine. Just reminder that those are not official court records. The official court record is what the court reporter takes down. We have to say that now because there's so many ways to make a record of the hearing, so that aren't official. In any event, so here's what I generally understand. I try to start out this way so I can save you some time in explaining the background. I will start by saying this. Because we are at the motion to dismiss stage, I don't know that I need to know a lot about the underlying facts that have led to this dispute, other than what's been generally outlined in your briefs. Here's what I generally understand. Is it Gad or Gaddy?
It's Mr. Gade.
Gade, thank you very much. So Mr. Gade, on behalf, as derivatively on behalf of the company of which he is, I believe, currently a 15% member, filed this action against Red Clay. My understanding is that Prasanna is a member of Red Clay, but that Mr. Gade is not a member of Red Clay individually. And in response to that, Mr. Patel filed counterclaims regarding a breach of fiduciary duty. And in response to that, there was a motion to dismiss, asserting that Mr. Patel doesn't have standing to assert a breach of fiduciary duty claim and or that there is no fiduciary obligation by a 15% member. And then I think the last thing I saw most recently was Prasanna seeking to intervene as a party defendant and or counterclaim plaintiff as to the breach of fiduciary duty. So that's where I think we are procedurally at this point. And I may have skipped the basis for the derivative action currently is, and I do want to hear a little bit about that. In name, it seeks an accounting. It cites the relevant statute for a member to seek an accounting, which is OCGA 1411-313. There's some verbiage in there implying that perhaps they are also, or in the alternative, seeking equitable accounting. But that's an open question as to whether that is requested, and if it is, whether that any of that relief is recoverable, which of course is the basis of the motion to dismiss Mr. Gade's claim for an accounting and then by extension a request for attorney's fees. So that's where I think we are currently, and I think procedurally, unless y'all disagree with me, it would make the most sense to start with Mr. Zachman's motion to dismiss. If you guys could give me 1 minute to take a quick break, I'll be right back with you.
Of course.
Sorry about that. Mr. Zachman, you want to go ahead?
Thank you, Your Honor. Plaintiff's derivative claim should be dismissed for two main reasons. The first reason is it's an improper derivative action for which Mr. Gade does not have standing to bring. The second reason is even if Mr. Gade had standing to bring his claim, as you note, he seeks a standalone accounting claim that is dismissible without a separate claim for damages under Georgia law. I'll start with the first reason, that Mr. Gade's claim is an improper attempt at an end run around both the agreement between the parties and Delaware's derivative statute. As Your Honor may have seen, but I'll give a little background, it was addressed in both parties, both the complaint and counterclaim. These parties are and have been partners in a variety of enterprises developing real estate. Sometime last year, they entered into an agreement to change the ownership structure of the entities at issue here. Those being the Prasanna entities, which include Red Clay. As Your Honor noted, Prasanna is the sole member of Red Clay. However, that agreement, which is referred to as the equity agreement in our papers, was not simply a transfer of ownership, though it did do that. It was also a complete relinquishment of rights, duties, and obligations of, in this case, Mr. Gade regarding the Prasanna entities. And the Prasanna entities includes Red Clay. As cited and as attached to both our motion and the complaint, that equity agreement, under that equity agreement, Mr. Gade agreed to release any and all, and here I quote, any and all rights, powers, privileges, and authority in the management, operation, decision-making, and or control in each of the Prasanna entities, which includes the derivative plaintiff in this case, Prasanna LLC.
Question, Mr. Zachman. I certainly understand that parties can generally contract to agree to do anything that's lawful. And certainly I am aware and understand and have seen agreements whereby a member relinquishes all management authority or et cetera. But if the equity agreement really is as broad as you characterize it, to completely and fully remove any and all rights that a 15% minority member would have, up to and including, for example, dissenters' rights under most corporate statutory protections, can you do that? And if you can't, doesn't that mean that that language is not as broad as you are characterizing it to be?
Good question. You can, Your Honor. And we cited a Delaware case in our brief that we think does that. That when the parties change ownership, if this had been a mere exchange of, let's say, management interests or a change in manager, Delaware corporate law or Georgia corporate law would be just that. There'd be a change in management, but it wouldn't be a relinquishment of any ability, any right, any ability to control the entity. It would just be a relinquishment of the right to control that member, that entity as the manager. However, the equity agreement was broader than that. It was more than just a change in the manager of Prasanna, and it was more than just a change in the ownership of Prasanna. Under Delaware law, that sort of relinquishment of all control, including, as you note, the right to bring a derivative suit, the right to do through a derivative action what Mr. Gade agreed not to do in any circumstance, can be agreed to under contract, and that's the case cited in our briefing. On that basis alone, and that basis alone, Mr. Gade's complaint is dismissible. However, there is a second reason that Mr. Gade's derivative action is improper, and that is because under Delaware law, even if Mr. Gade had not waived his right to control Prasanna derivatively, he is obligated to make a demand against Prasanna. In this case, a demand that Prasanna do the thing that he is trying to get it to do here, which is seek Red Clay's records, assume it either, as Your Honor notes, either through some sort of equitable accounting claim or through Georgia's LLC statute.
And
That
what does, sorry, Mr. Zachman, what does, oftentimes there is a affirmative sort of obligation to ask, be rejected before you can undertake some action. There is sometimes case law that talks about whether or not such an action would be futile. What does Delaware law say about that?
Delaware law has a three-part test for futility, and that's a good question, Your Honor, because I think that's what Mr. Gade claims. Now, he never asked, so I don't think there's any evidence in the record or the pleading as to whether it would be futile. But Delaware law requires, and it in doing so, it applies its corporate statute to the LLC statute, but they're analogous for obvious reasons here, Your Honor. It requires that they show that the controlling party have a material benefit or have a material interest in the transaction being demanded. There's a likelihood, some likelihood that controlling party, in this case, it would be, I believe Mr. Gade would claim it would be Mr. Patel, has some likelihood of a liability on the claim that's being asserted, and that there is not an independent actor, Your Honor. We cited this, we cited these cases in response to Mr. Gade's claim that, well, we didn't demand anything of persona, but that would have been futile. But that raises yet another point. So they haven't shown futility under Delaware's three-part test, which basically says you have to show that the person you're asking it's a conflicted transaction. But here, their derivative action is improper because they are seeking to do through derivative action what they do not have the right to do under Georgia law. And because, as Your Honor noted in your summary, Mr. Gade is not a member of Red Clay. He does not have a statutory or equitable right to obtain through Georgia law the documents of Red Clay. What he is seeking to do, however, is launder that request through persona, through a derivative action. He demanded, Mr. Gade, pre-suit, and his pleading set this forth, he demanded that Red Clay provide documents to him related to Red Clay. Red Clay said no. They properly said no because Mr. Gade is not a member of Red Clay, and Georgia law holds that where a non-member requests documents, the LLC is not obligated to provide them. Gade cannot do an end run both around the Delaware derivative statute by never making a demand on persona, and then say, well, I didn't make a demand on persona because it would have been futile, because look, I made an improper demand on Red Clay, which they rejected. In other words, he's trying to prove futility by showing that Red Clay stood up for its rights and failed to give documents to a non-member. So he cannot prove futility under Delaware law, either under the test, but maybe more saliently, Your Honor, because this is an attempt at an end run around Georgia's LLC statute, which says only members get documents from LLCs. He is not a member. He can't become a member by filing upstream derivative suits. If it were otherwise, you could basically you could completely rewrite Georgia's LLC statute. So for that reason alone, his complaint should be dismissed. And that's a little bit of a dual reason. It's both an improper derivative claim, but it also goes to the substance of his claim. If it's interpreted as a claim under Georgia's LLC statute 1411-313, it would fail on the merits for that reason alone, that Mr. Gade is not a member of Red Clay, and he very clearly doesn't have right to their documents. And that's supported in the Ridgewalk Holdings case, 358 Georgia App 717 that's cited in our briefing. All that said, and independent of all that, so he doesn't have standing under Delaware law. He doesn't have standing because he released his standing expressly under the equity agreement. And he neither has standing nor has a right substantively to seek these documents because he is not a member of Red Clay and cannot become one derivatively. But even if all that was true, Your Honor, his accounting claim, which, as you note, is the only one being pled, it's simply an accounting claim. I agree it's unclear the basis for that claim, but he seeks an accounting above and beyond anything that would be allowed under 1411-313, and that claim is dismissible because he asserts no additional claim that would entitle him independently to damages. Georgia law, as we've cited in our briefing, Your Honor, and I won't repeat it extensively here, but Georgia law is clear that such a claim can't stand independently. I'm happy to answer any of the other any other questions the court may have. I'd reserve just a small amount of time if there's anything to rebut, Mr.
Nope.
Kapler.
And I'm happy to do that. Thank you, Mr. Zachman. I do want to note and I apologize for being a little nitpicky, but just procedurally, I think maybe both of y'all filed reply briefs. I know I at least saw one. To the extent that you've mentioned it just now, Mr. Zachman, just so you know, I've not read them. And the reason is that I have a standing policy that says you can't file a reply unless you email and tell us, hey, is it okay if we file a reply? And I didn't get any of those. So my general practice is if it wasn't authorized to be filed, then I'm not going to read it. That doesn't mean you can't make those arguments here. I just haven't had the benefit of that briefing as I had the other briefing.
Understood, Your Honor. Apologies based on the timing. Did not notice your standing order on that.
It's totally fine. That's why I tell people so that the word will get out and people will know. So it's fine, Mr. Zachman. I wasn't as much chastising you. That wasn't the intent. It was more to make sure you understood that I did not have the benefit of your briefing to the extent those issues were addressed in the reply. Okay.
Thank you, Your Honor. I would I'm happy to seek further consent from the court. I'll just note if Your Honor would appreciate it, I can provide a citation to the case I cited in which under Delaware law
About futility.
Well, I can cite both the futility case and the case that allows a party to release what they otherwise, their other contractual corporate rights.
Yep.
That's the R&R Capital case. I believe this was cited in our initial briefing, but just in case, 2008 Westlaw 3846313 at 4, and also in Ray Pack Liquidating 658 BR 305 at 316.
Okay.
For the idea that those cases are for the idea that under Delaware law, you can release your rights that you may or may not otherwise have statutorily. And then the futility case that I cited, I believe it was also cited in our main brief for a different purpose, but it's the Zuckerberg case, Zuckerberg 262A3D 1058.
Okay. Thank you, Mr. Zachman. Mr. Kapler?
Good morning, Judge. Thank you.
Good morning.
So, of course, the court knows that on a 12B6 motion, all facts are assumed to be true, and all inferences from those facts are assumed to be true. And you take those to the benefit of the non-moving party, which for this motion, of course, is us. So here are all the allegations that matter and which show at a minimum the viability of the claim. But if we missed a magic word, and I don't think we did, if we didn't say a word that Mr. Zachman thinks we ought to say, the proper remedy isn't dismissal with prejudice by this court. It's leave for us to amend in a short period of time to reallege the facts or the allegations that Mr. Zachman or perhaps the court thinks we missed. That's the proper relief here, not dismissal with prejudice. So let's go back to the factual allegations and what we alleged happened and how those allegations show we're entitled to some relief. First, as the court recognized, Mr. Gade and Mr. Patel are the members of Prasan. Mr. Gade is the 15% member. Mr. Patel is the 85% member. Prasanna then is the 100% member of Red Clay. Mr. Patel is the manager of Red Clay. Mr. Gade sent notice to Mr. Zachman as counsel for Mr. Patel and said, and this is Exhibit 2 of the complaint, quote, by virtue of Mr. Gade's membership interests and rights in the persona entities, as that is defined in the agreement regarding equity interests, Mr. Gade requests a list of documents. Now, the use of that term is important because, again, we're assuming everything is true and all inferences derived from those allegations are also true. So when Mr. Zachman says we never request the documents or the information from Persona, that's just not correct. Mr. Gade made a specific request for the information of the Persona entities. And when you go into the equity agreement, which is attached to the defense responsive papers, the Persona entities is defined as Persona itself, Red Clay, Greenfields, Ventures 3. In fact, it says, quote, and this is the second whereas paragraph of the equity agreement, quote, all of which, including Persona, are collectively the Persona entities. So what Mr. Gade did in response to not having the information, and this is important too. It's not like Mr. Gade just woke up one morning and said, hey, we want all this information. Mr. Patel was repeatedly asking Mr. Gade for money. And this has been the nature of their relationship for a long time. He was repeatedly asking Mr. Gade for money. And Mr. Gade said, if you want $1 million, you need to tell me what is going on out there. I'm a 15% member. There's a note that is maturing, a $9 million note that is maturing. And if you want us to give you money, we need information. It's simple. Give us the information you want, and we'll consider giving you money. Well, he never did. And Mr. Gade, because he's a 15% member of Persona, which is a 100% member of Red Clay, is entitled to information pursuant to Georgia law and Delaware law related to the operations of the company. It's simple. And we know that there's a note maturing imminently. We know because Mr. Patel's begging him for money that there's an insolvency issue, and Mr. Gade's interests are at risk of being prejudiced.
Well,
so he
forgive me
asked,
for interrupting, Mr. Kepler, but I mean, due respect to the characterization you're making, all of that would make in complete sense if the lawsuit was Mr. Gade seeking an accounting from Persona of its business interests, which you might argue include the operation of Red Clay, if in fact you, if I'm understanding correctly, that the Persona entities are defined as including Red Clay in some document. But that's not what Mr. Gade has done. Mr. Gade has said, I want documents directly from Red Clay, an entity of which he is not a member. And so that's sort of everything that you're telling me, all of that sounds reasonable in terms of the steps Mr. Gade is undertaking. But what of the fact that the action he's taking is against Red Clay individually and not from Persona?
well, and that's why it's a derivative case, Persona against Red Clay.
Right.
Because what will happen is Persona gets Red Clay's information because Persona is a member of Red Clay. Mr. Gade can then get Persona's information because Mr. Gade is a member of Persona. So it's a two-step approach. Presumably, once Persona has the information, which it is entitled to, which is what this derivative case is all about, then Persona will voluntarily provide it to Mr. Gade. But it hasn't yet. Persona has not properly responded to Mr. Gade's request for documents, and therefore it's futile. And Red Clay has not responded either. And so, but again, if that's a nature of an issue, it's a pleading issue, not a substantive on the merits issue. The proper relief there would be say, okay, amend it and recast it in a different category. But if we go back to the documents and we go back to the requests that were made, again, Mr. Gade says, pursuant to his membership, interest, and rights in the Persona entities. And Mr. Zachman responds and says, well, you're not a member and all these kinds of things. And we go back and forth a couple times. The letters are attached to the complaint and incorporated therein. But then one important thing happens. Mr. Zachman says, we will provide information regarding the amount of the current loan and the balance thereof. And importantly, he doesn't say Red Clay will or Prasanna will. He says Mr. Patel will. And Mr. Patel, of course, is the manager of Red Clay and the other member of Prasanna. So in terms of a conflation of entities, Mr. Zachman wants to really separate these entities now and do this very technical approach. Well, Prasanna, Red Clay, et cetera. But that's not how the parties have operated. And you can see on Mr. Zachman's letter, Mr. Patel will provide information regarding the amounts of the current loan and the balance thereof. And he never did. He never did. And so he tells us he's going to. He doesn't. The loan is maturing, or we think the loan is maturing. What is a member to do at that point? Other than bring an action under the law to compel the production of the information that we're entitled to. So then that goes back to the equity agreement and whether or not we could waive those rights. Mr. Zachman has taken an extremely broad brush of the relinquishment of management rights. And he contends that the statement where we relinquish any and all rights, powers, privileges, and authority whatsoever in the management, operation, decision-making, and or control somehow means that Mr. Gade has waived his statutory rights as a minority member. And that's just not the law. It is absolutely not the law. What the law is that if you are going to waive those rights, and in certain circumstances you can, it has to be a knowing and intentional waiver of those rights. What that paragraph means is that Mr. Gade is no longer the manager of the entities. Because importantly, he used to be a co-manager with Mr. Patel. The point of this wasn't to say, Mr. Gade, you are going to remain a 15% member, but from henceforth, you have no rights at all to information, to inquiry. According to them, Mr. Gade has no rights at all, period, the end. And that's just not the agreement. It's not. And it's not the law. The R&R capital case from Delaware that the defense cites, the waiver was express. It wasn't this inference of, well, we're waiving rights to management, therefore we have no rights to dissolve. The court quotes the provision, and the provision in that case, and the R&R capital case says that each member accepts the provisions of the agreement and waives and renounces such member's right to seek a court decree. It's an express waiver of statutory rights to seek dissolution, not an inferred waiver or some kind of a parole waiver. It was an express waiver. And when you look at the equity agreement in this case, that is not what's in that document, not even close to what's in the document. So their broad brush with that language is wrong factually. It's wrong on the document. It's wrong on the law. And on a 12b-6, it's certainly wrong because the inferences are in our favor. To the extent that agreement is ambiguous, which it's not, but the best case they can argue is that it is somehow, and that language somehow ambiguously creates a waiver of all rights, statutory or otherwise. That's not, on a 12b-6, they don't win that. We do. Because the inferences of the document are in our favor, not theirs. So then let's talk about this futility thing. What Mr. Zachman says is that there's three factors, and that to show futility, you have to have a material interest, risk of liability, and no independent director. Those are the three factors he said. Well, let's talk about the futility. There is no other person.
Sorry, forgive me for interrupting. Sorry. Before you start talking about futility, and it may be one of those belt and suspenders lawyer kinds of things, right? But I thought I understood your primary argument to be that Mr. Gade did ask Prasanna to obtain the materials. And theoretically, I assume you would argue that that shoehorns it into the Delaware requirement that you request that the corporation undertake the, action that you want, and then they refuse. So just to make sure, your primary argument is that he did ask and Prasanna either affirmatively said no or failed to undertake the thing that it said it would, that you want it to do, which was to obtain records from Red Clay. And in the alternative, as we lawyers like to do, in the event the court were to find that what Mr. Gade had asked for previously didn't qualify as a request that would justify undertaking derivative action, that you're disputing what the standard is to demonstrate futility. Am I following you so far?
That's exactly right.
Okay, thank you, Mr. Kaplan. Go ahead.
That's exactly right. So we think we did comply, like you said. We think we did comply. We think it's broad enough, particularly on 12b-6, to be sufficient. And we also believe, of course, that the law doesn't require magic words to be pled. It's the substance and the inferences drawn therefrom, not magic words. But if the court is inclined to say, you know what, your letter wasn't good enough for whatever reason, or you need to establish futility, we have. And the reason we have is that the three factors that Mr. Zachman contends apply here, and let's assume for the sake of argument they do, we satisfy them. So those three factors that he identified are whether there's a material personal interest, whether the director would face a substantial likelihood of liability, and whether the director lacks independence. So let's talk about that. Let's talk about the first factor. Is there a material interest? Of course there is. Prasanna is the 100% member of Red Clay. Mr. Patel is the 85% member of Prasanna. Red Clay is the entity that, at least as far as we know, is in default of a $9 million loan that secures its only asset. There's absolutely a material interest flowing through that flow chart. Prasanna has a material interest in Red Clay because it's the 100% member, and Mr. Patel has a material interest in Prasanna. And Mr. Patel is the manager of Prasanna, as far as we know. So he has material interest in that regard too. So the first factor of futility is met. The second factor of whether or not there's potential liability. Well, of course there is. We've brought the action, which shows there's potential liability. And Mr. Patel has received a material benefit from it because he is, again, the 85% member of Prasanna, and he is directing the affairs of Red Clay. So he has a material benefit as well. And of course, with that, those benefits come liability, and we've alleged liability. We've alleged the entitlement to records, and we've alleged attorney's fees and some other things. So then the third question is there independence? Or is there another, independent person whom could have taken steps to protect Prasanna's interest in uncovering the records of Red Clay and Mr. Gade's right to get those information from Prasanna? Well, the answer is no. There is nobody else. There's nobody. If Mr. Gade can't send a request for the information of the Prasanna entities to Mr. Patel's counsel, to whom can we send a request? There's nobody else. There is no independent party. So when he's already refused to give us the information, when he represents to us that he will and then still doesn't, is he suddenly going to change his mind and file a lawsuit against himself? Of course not. Of course not. It's got to be futile. I mean, the fact that we're here shows it's futile. And the fact that they've asserted that Prasanna is apparently, they filed this yesterday, and I haven't had a chance to really look at it yet, but that the fact that Prasanna is seeking to intervene in this case, not because of Mr. Gade, but because of Mr. Patel's actions, that proves it's futile. Because now Mr. Patel was causing Prasanna to purportedly bring claims against Mr. Gade. It's absolutely futile. There's no other way around it. So in short, and I'm happy to answer any other questions the court might have, but in short, we've properly alleged the flow of membership rights. We've properly alleged that we made an effort to get the information and they refused to give it, even though they promised us they would give us some of it and never did. We've alleged that Mr. Patel is the one who's refusing to provide the information, and we've alleged the rights required for standing. With all of that assumed to be true on a 12b6 and all the inferences from that assumed to be true for 12b6, the motions ought to be denied outright.
I do have a couple of questions.
Yes, ma'am.
So I understand that for the accounting action that's alleged in the complaint, it in name is alleged as a 14-11-313 accounting action by a member. And I understand that your position is that if you are appropriately bringing a derivative action, then Prasanna is a member of Red Clay and is entitled as a member to that accounting. Separately, there is the phrasing somewhere in the paragraphs of your count 1 for accounting that says the phrase equitable accounting. And so there's some effort by the defendant in this case to talk about the fact that an equitable accounting claim can't stand without a cause of action for damages, et cetera. Now, your answer may be that is merely that's something that can be fixed through different pleading. But I guess my real question is that one of those you didn't mean to use it as a term of art and are focused on the 14-11-313 accounting, or were you intentionally seeking to potentially invoke the right to an equitable accounting in the alternative to the statutory accounting?
Thank you, Judge, for that question. No, we are seeking the statutory accounting pursuant to the statute.
Okay. Anything else you'd like to add, Mr. Kapler?
Yeah, so the last thing I was going to say was, to the extent the pleadings are deemed insufficient, what we would request would be a short period of time to amend and recast to allege any additional facts that the court might deem to be appropriate to establish the bona fides of the claim. And we could amend that within 10 days, something short like that.
Okay. Thank you, Mr. Kapler.
Thank you.
Mr. Zachman, it's your motion currently, the motion to dismiss the underlying complaint. So you get the last word, sir.
Very briefly, I just want to address a few things. The first is I want to make clear the distinction between a demand for documents and a demand to file a derivative suit. Those are two different things. And I think Mr. Kapler confused the demands of the letters back and forth that are attached to his complaint. Those are demands for documents. We contend they're improper for the reasons that I've discussed. Most notably, they don't have a right to documents because Mr. Gade is not a Red Clay member. That's different than the demand under Delaware law that you demand before you file a derivative suit. That's what keeps minority members from suing all the time. They have to allow the controlling shareholders, or in this case, the controlling manager, to determine whether they want to bring this suit or not. As to futility, I just want to be clear. You can't rely on the action that is brought derivatively itself as proof that the managing members are monetarily have monetary exposure, or else any derivative action would establish that branch of futility. And I just want to one last thing. I think Mr. Kapler mentioned that this would be a two-step process. That they'd sue here to get Red Clay's documents, and then because they are, or Mr. Gade is indeed a member of Prasanna, he would then make a demand on Prasanna for those documents having been gotten in this action. But you can't do that under Georgia law. There is no two-step process under Georgia law because step one, the step that we're here talking about today, is improper. And that's our argument, Your Honor, that you can't get around Georgia law by breaking it down into a two-step process. And for that reason, the motion should be granted and the complaint should be dismissed. Thank you.
Okay. Thank you, Mr. Zachman. I don't want to get too much into the substance, but one question I did have is, if in the light that Mr. Kapler has characterized the communications back and forth that are attached to the complaint and so properly before the court on a motion to dismiss. If in fact the persona entities include red clay, and certainly a corporate entity has an obligation to have information about its business interests. I guess I'm not sure where the loop was closed, and maybe that's part of your argument, Mr. Zachman, that there's a procedural defect here because the loop wasn't closed. But did Persona, it doesn't sound as if Persona responded and said, we don't have those documents. It sounds as if there was some response by Mr. Patel, and I'm not willing to accept Mr. Kapler's invitation to say that the simple fact that you referenced an individual instead of the corporate structure, et cetera, means that we've somehow turned it all into a mishmash. But, you know, there was some indication that Mr. Patel would provide those documents. But of course, because it was stated in that way, it's difficult to tell which hat Mr. Patel was wearing when he said he would provide that information. And if he was wearing the majority shareholder or majority member hat for Persona, then Mr. Gade would have a right to ask for that information, would he not? Or is it your position that in signing the equity agreement, he gave up even the ability to say, hey, I want some information about what my 15% rights demonstrate, or what you're doing, just so I know, even if I don't have any authority to direct the activities of the company?
That's a good question, Ryan. No, we are not saying that last point. For the reason that this is a derivative suit by Persona for red clay, the requests for documents were a request for red clay's documents. And so when we responded for Mr. Patel as manager of red clay. Red clay is not obligated to give those documents over. To the extent there's a demand for the documents from Persona, and if you're hinting at perhaps it was unclear, perhaps the parties could work that out if there was a separate request. But as this complaint shows, and what we're here to address today is, does Persona, through Mr. Gade as a derivative plaintiff, have the right to get documents from red clay? And to do that, they have to, and I believe contend, they made a demand for those documents from red clay, because the Georgia LLC statute states that if you make a demand for documents and then that demand is refused, then you can bring an action. So what's relevant here is that they made a demand from red clay. Red clay said, no, you're not a member. If there is a separate demand that was not understood from Persona, that we would address that separately, Your Honor. Does that answer your question?
It does. So here's my take on this, and I'll just say, as someone who, you gentlemen knew what you meant when you wrote these letters. But my review of these letters is that there is a bit of mishmashing and conflating and failure to separate. Because, for example, Mr. Kapler's original letter certainly asks for red clay document information, but as I review it, it doesn't say it's asking for it. The Exhibit 2 doesn't say that it's asking for it from red clay. It says he wants that information. And then there's some reference to the agreement regarding equity interests, which presumably is an agreement that applies and is relevant to Persona. And so I do think there's some inexact communication, that whether deliberate or inadvertent, resulted in this sort of confusing position that we're in. And I'm not sure that this derivative action is the appropriate vehicle for us to sort all this out. But I also think that Mr. Kapler's point is a valid one, which is if all the right entities are here, right? We all know who's at play, which is Persona and its two members, Mr. Patel and Mr. Gade. Then it feels like Kapler should have the opportunity that Gade might be able to figure out a different or better way to present these issues to the court. And so one question I have for you, Mr. Zachman, is to Mr. Kapler's point, whatever the nature of the relief is, do you agree or do you have strong, well, agree is the wrong word. What is your response if the court were inclined, or concerns if you want to share them, if the court were inclined to respond to your motion to dismiss by saying there might be some shortcomings? I'm going to give Mr. Kapler an opportunity to file an amended complaint to see if he can address those. And if he can, then that will, you can tell me that that obviates, obviously we'll still fight about the substance, obviates the need for the motion to dismiss. Or you can say, no, Judge, I don't think that he's addressed the shortcomings. And so I still need a ruling on your motion to dismiss. What are your thoughts, sir?
Thank you, Your Honor. Without having seen it, I'd reserve my client's right to assert shortcomings of an amended complaint. I would say my concerns are twofold. To the extent that it is an amendment that seeks to do what this complaint does, I don't see that Mr. Gade can solve the objection that he's not a member of Red Clay and is not entitled to records. However,
well, due respect, Mr. Zachman, I've never understood that to be the argument he's making. When I know when I initially looked at it, that was my first thought. But if in fact it's a derivative action, what Mr. Gade is saying is Prasanna is entitled to those records as a 100% member of Red Clay. And so then really the only question is Mr. Gade properly empowered to bring the action and make the demand on behalf of Prasanna? Now, whether they are or not is the part of the pleading that I'm not, that I think Mr. Kapler might be entitled to a second bite of the apple. But I agree with you, Mr. Gade is not a member of Red Clay and would not have the authority or right to directly seek records from Red Clay. Now, separately, he would, subject to the continuing argument you've raised about whether he gave up such rights in the equity agreement, typically a member of an entity under Georgia law would have a right to ask for documents and information from the corporate entity of which they are a member. And if Red Clay, wholly owned by Prasanna, is one of the Prasanna entities, then there's an argument that Prasanna has an obligation to have information about it. And when it was requested, who was it requested from and who was doing the requesting? And all of that, again, to me, it's the issue is which hat was everybody wearing when everybody was making those requests? And if Mr. Kapler believes he can do a more precise job of arguing which hat everybody was wearing, then I would be better able to figure out if there's a horse to ride here. Mr. Zachman?
Understood, Your Honor. I'd say I understand all that, and I believe my client would take any request and evaluate it in good faith. That my one concern, or maybe it's not a concern, maybe it's something the parties can work out, is that some of our objection has to do with, as I think you note, Mr. Patel's right to consider, as manager of either Red Clay or as the manager of Prasanna or of both, a properly specific demand. And then if that demand is rejected and Mr. Kapler pleads who rejected it, then an amendment, we would certainly consider that. Which is to say, Your Honor, that I see that you may be inclined to allow Mr. Kapler to amend, to maybe be more specific. And I'd just ask, maybe it's something the parties can work out, that Mr. Patel and Red Clay and or Prasanna, whoever this amendment might be directed to, have an opportunity to review that request before we do this whole thing again. In case we do not in fact have objections to whatever the demand or request is that could obviate a derivative suit. If
Right.
Mr. Kapler can't solve those, we may be back here arguing about derivative suits again.
Okay. I know I agree, Mr. Zachman. And so part of my question is, if I were, Mr. Kapler has indicated he feels like he could file something amended to clean up any concerns that the court has expressed here very rapidly. But I guess my question is, it sounds like you think maybe there's some work in the interim that the parties might need to do. I mean, here's the thing. Not only are you guys very sophisticated corporate counsel, but it seems to me from what I've heard that Mr. Patel and Mr. Gade are also quite sophisticated businessmen with sophisticated business interests that are intertwined and might have ripple effects on lots of other things. And so I'm happy to give the parties a realistic amount of time to try and work through these issues. And so if, as I said, well, now that sort of leads to two questions. If I allow Mr. Kapler an opportunity to amend, one question is, how long do you think it's reasonable, given Mr. Zachman's stated preference for the ability to engage in maybe some further engagement about what's actually being sought and from whom and in what capacity? How much time is really needed to do that realistically? That's number one question. And number two question is, what effect does it have on the also pending counterclaims and motions to dismiss the counterclaims and motion to intervene by persona? Mr. Kapler, your thoughts?
Sure. And, I do think, and Mr. Zachman and I get along great, in dealing with each other. So I do think an opportunity to, if the issue really is to clear it up, from whom to whom kind of thing, then, 10 days is probably not enough, because I would send a note and give them an opportunity to review and consider it. And then if that fails, then bring an amended action. So that's probably more like a 30 to 45 day time frame than a 10-day time frame.
Okay.
Because, give them 10 days at least to review the letter or whatever. So that's probably a little bit longer. So I would say 30 to 45 days is probably fair and reasonable.
Okay.
With respect to the other items, and I do think our motion to dismiss is likely mooted under the law based on their amended complaint that I think they filed yesterday. And
amended counterclaim, yeah.
Yes, ma'am. So I think our motion is probably mooted anyways.
And of course, if you were to file an amended complaint, it would have the potential effect of mooting all of those other things anyway. So
that's right. So I think ultimately their amended counterclaim moots our motion. If we file an amended action, it moots their motion, at least for now. And we're going, it's like a Civ Pro final exam on who's where and when.
We wouldn't do that to a bunch of poor law students. We wouldn't do that.
Oh my goodness. So I think that's probably what happens, procedurally with the court is send a note, give us a little bit of time to work things out, and come back and see where we're at.
Okay. That is where I'm going. So then my question procedurally is, any suggestions on how to accomplish that in the record? I mean, I can certainly enter something that says, the court heard argument of counsel and that the court's going to defer ruling until X date, at which point the parties will report back. Or, I mean, potentially the easier way to do it, or the more direct procedural way, is to say that is to just enter an order allowing the plaintiff to file an amended complaint on or before a certain date, that would be 30 to 45 days from now. And maybe y'all work it all out and don't need me anymore and y'all can just dismiss, or maybe Mr. Kapler feels it necessary to file that amended complaint. Any thoughts if I were to do that, Mr. Zachman? And if I do 30 to 45 days, does that, to Mr. Kapler's suggestion, do you feel like that's enough time to at least attempt to do what y'all think needs to be done?
I'll start by saying yes, I think so, Your Honor. I will state for the record, we submit our motion to dismiss. However, I understand the court's preference, and I think that'd be a reasonable course of action to take, to state if that is the court's ruling. I think we'll figure out whether Mr. Kapler can cure or we can resolve any of the deficiencies we've noted in our motion to dismiss, if that's the court's ruling. I do agree the amended counterclaim moots their motion. I think that you could just be denied as moot. We did file a motion to intervene as lawyers do with belt and suspenders, though we believe
And that motion has the benefit from a timing perspective of, one, potentially being mooted if we get there, but also two, not yet being ripe. So I don't have to deal with it just yet until y'all figure out what to do with it. So I think that is what I'm going to do, Mr. Kapler, is I'm going to enter a very brief order that allows you to file an amended complaint on or before, hang on. On or before April the 21st, which is somewhere between 30 and 45 days. If your staff, if one of y'all could send me just a literal 1-page, 3 sentences order that accomplishes that, then I will edit it if I think I need to, and otherwise I'll get it on file. And then we will go from there. What y'all can expect is that we try to keep these things moving. And so what we'll be looking for on the 21st is either an amended complaint or, prior to that date, some indication from the parties that court's efforts are no longer needed and we're going to move forward and dismiss, or whatever it is y'all might decide to do. My issue will just be to get the case procedurally postured so that I can send you off to go do discovery or whatever it is I need to do. So, okay. Any questions or anything else that's needed from the court today, Mr. Zachman?
Just to be clear, I'll work with Mr. Kapler on this proposed order. The order would be that plaintiff will have until the 21st to file an amended complaint.
Yes, sir.
And that the and the plaintiff's motion to dismiss is moot. Would you intend
I'm not going to say it's moot, and the reason I'm not going to say it's moot is that while certainly you have the right to file a whole new motion to dismiss the complaint, I have found that it can be procedurally much more efficient if Mr. Kapler files an amended complaint and your position is he's not cured the defects, then your motion is still ripe and the court can still rule on it. And so it's really more, if you want to be precise about it, a deferral of ruling on the motion to dismiss. And what I typically have done in the past is, once I get an amended complaint, wait a respectable amount of time for people to process it, maybe 10, 15 days, and then reach out to the party and say, hey, does this resolve the issue so we can move on? And I'll just enter an order saying the motion to dismiss is moot, or does it not? In which case, or do you plan to file a new motion to dismiss? Those are all options, but that's a conversation we'll be having right around the end of April based on whatever Mr. Kapler files.
Okay. So then I think I understand what we'll submit to the court.
Understood. Mr. Kapler, any questions from your position?
I'm good. Thank you, Judge.
Okay. Well, thank you all very much. Have a good day, and I will look for that proposed order. As soon as you get it to me, we'll get it on file. Okay. Thanks, everybody.